Good afternoon. Thanks very much for having me. My name is Matt Gardner again. I'm an attorney in Washington, D.C. With Wiley Rein, and I've been there for about 2 years, and I focus primarily on cybersecurity risks, policies, and procedures for companies. Before that, for about 9 years, I was a federal prosecutor where I prosecuted a wide range of crimes, but primarily computer crimes, and a wide assortment within that. So that's my background real briefly. Let's see if I can work this. And I'm going to talk about a couple different things. Go through initially the legal framework for vulnerability disclosure programs. What's the Computer Fraud and Abuse Act, the main anti-hacking statute, how that works with vulnerability disclosure programs, and when things are legal and not legal. So that's going to be kind of my beginning part. I'll hit briefly on the emergence trends that we have seen within the federal government to encourage vulnerability disclosure programs. You've heard about that already, and I'll amplify that as well. And then talk about some of the benefits and risks to a company for having a vulnerability disclosure program. And lastly, if a company does decide to start one, what are some key takeaways that, from the legal side, that we are advising clients are good things and that they should pay attention to. Okay. So starting first with kind of the legal framework for vulnerability disclosure programs. Ethical security researchers often operate in a very gray area. It is not obvious all the time what is okay and not okay to do. You heard at the beginning the definition of who is a hacker. There's somebody who wants to know how something works. That curiosity, obviously, legal, that's good. But when you start kind of playing around with something like somebody else's application or intellectual property, their website, you can cross the line sometimes very quickly and be on the other side of the law. So I want to talk about that in a little more detail to kind of flesh that out, what that means. So the main statute on the federal level that prevents computer hacking is the Computer Fraud and Abuse Act. This is a fairly old statute. It was originally enacted in the 80s, and I think most people would agree that it's a bit of a mess. It feels antiquated. A couple points to talk on here. In the second bullet there, it talks about knowingly accessing a computer without authorization and intending to commit fraud that's greater than $5,000. So that's illegal, that makes sense, right? If you go into somebody's bank account and you hack in and you steal $5,000, that feels like a crime, right? That's pretty clear. The last bullet point, too, I think feels a little more clearly criminal. When you send malicious code to a computer without authorization and you cause damage to that computer. Wide range of conduct could be covered by that, like hacking into a company's surveillance cameras throughout the company and disabling them all. Again, pretty clearly criminal conduct. The first bullet point's a little bit surprising, perhaps. Merely accessing a computer without authorization and thereby obtaining information, pretty much any information, is going to be illegal. And that's really broad. It's basically just getting into somebody else's computer at all. Not breaking anything, not trying to steal anything, just getting in is going to put you afoul of the Computer Fraud and Abuse Act. One thing that is not in the Computer Fraud and Abuse Act is a good faith exception. Something that says if you're just tinkering around with someone else's application or website and you really want to do it for altruistic reasons, to understand how it works, to educate yourself, to help the company out, there's no exception at all for that. So that's not included here. Vulnerability disclosure programs can address that. And a well-run vulnerability disclosure program can take the ambiguity that exists for a lot of security researchers now and help to clarify the rules of engagement, to clarify what's legal and what's not. And there's two concepts within the Computer Fraud and Abuse Act that this really keys off of. its conduct becomes illegal when it's done without authorization, like you're a true outsider to the information system, but you access it. Or you exceed your authorized, you act in excess of your authorization. In other words, you're allowed to do something on a computer system, information system, but you're not allowed to do something else. And occasionally that can also be illegal when you do that other thing. So those two concepts really boil down to consent. What has the owner of the information system consented to allowing somebody to do? That is going to distinguish the line between what's legal and illegal. And a well-crafted vulnerability disclosure program is going to make that granting of consent very clear. You heard from the last panel as they were talking about their interactions with companies, from boilerplate VDP programs to more specific ones that say you can play on this application but nothing else. Or the initial DoD Hack the Pentagon was, I believe, limited to one or a couple public-facing websites, but not the rest of the Pentagon, right? Those are providing limited grants of consent to the people who participate in the program, and that's what makes that conduct legal. So that is the really important dividing line. When, in the real world, the way this plays out is sometimes a little messy. And there aren't a lot of cases yet with vulnerability disclosure programs where someone has been accused of running afoul of the grant of consent in the vulnerability disclosure program. But I don't think it's hard to imagine that that could happen at some point. With the DoD example from this morning, the initial one was to, all right, this hackathon is, this vulnerability disclosure program, the bug bounty was set up just for a public-facing website. What if one of the participants in that had gotten into really top-secret information within the Pentagon that has nothing to do with that public-facing website? That's going to be in excess of their authorization, and it's going to much more likely be illegal and criminal. So these cases haven't played out a lot with VDP programs, but the courts have addressed the limits and kind of really pushed the limits for what consent and authorization means under the Computer Fraud and Abuse Act in other contexts. And there's two that I'll touch on, a few cases to kind of illustrate some of the limits here. The first is with employers and employees. So when you go to work, you use your employer's information system. And usually there's an employee handbook or something like that that provides limits about what you're allowed to do. And so this is a case from the Ninth Circuit, the Court of Appeals that covers California and much of the West Coast. And it basically says, look, if you access without authorization, like you're a true outsider, that's not going to be, that's illegal under the Computer Fraud and Abuse Act. Or if you're an employer and the employer has rescinded permission for you to access the information system. Most obvious example is you get fired. You used to be able to access a certain database, you get fired, now you can't. But it also, the gray areas that are a little more complicated are for current employees. You have a limited grant of authority to access your employer's information system, similar to the grant of consent by a company in a vulnerability disclosure program. So what if it says you're allowed to access database A, but you're only allowed to access that database to do payroll or something like that? You have a limited task that you're allowed to do with that. But then you take all the information that's in there and you sell it to your competitor. So that's going to make your employer unhappy. Is it also a violation of the Computer Fraud and Abuse Act? The Ninth Circuit in this case said no, that when you access information in excess of your authority and you misuse that information, that's actually legal under the Computer Fraud and Abuse Act. You might have some other issues with your employer if that happens, but that is okay in the Ninth Circuit. Other courts have held just the opposite. And you can see how this might play out in a vulnerability disclosure program setting where you've been told you can access A, and then a hacker does. They're looking at it, and then they misuse the information by doing something that's not authorized within the program. And I think that that's going to be an area that is unsettled, and we'll have to see how it plays out. This is another Ninth Circuit case that talks about in excess of authorization in these kind of situations where consent has been granted, but it's a little bit fuzzy as to what the borders are, what the lines are of that. The two cases I want to talk about. One is the Dru case mentioned here. That was a case where a mother posed on MySpace, obviously back a little while ago. She posed as a 17-year-old boy because if I recall correctly, her daughter was being bullied. And she went on MySpace pretending to be a 17-year-old boy and engaged in cyberbullying with with her classmates, her daughter's classmates. One of the kids who was bullied by the mom, who was lying about her age on Facebook or on MySpace, ended up committing suicide. So a very tragic case, and prosecutors weren't quite sure what to do with this. And they turned it into a violation of the Computer Fraud and Abuse Act. And they charged the mom because MySpace says, if you're going to use MySpace, you can do X, Y, and Z, but you can't lie about your age. And so the theory of prosecution was, if you go on MySpace and lie about your age, you are violating the consent that has been authorized by MySpace to use their information systems. Although this was a tragic situation, clearly a very aggressive theory of prosecution. And the last quote here is from the Ninth Circuit that critiqued this and said that it was ridiculous, that whatever the government assures us, the scope of the Computer Fraud and Abuse Act, if they say that they won't prosecute minor violations, we shouldn't have to live at the mercy of our local prosecutor. So DOJ has said, put out guidance that it doesn't do those types of cases. That if you're violating the terms of service of a social network, MySpace, Facebook, et cetera, and you're not causing harm that's, I think, over $10,000, that even if that is technically within the Computer Fraud and Abuse Act, that they're not going to prosecute those types of cases. But as the Ninth Circuit points out, the act, when read literally, is very broad and could encompass that. This is another quote from that same case that talks about the types of violations that might be at issue within the Computer Fraud and Abuse Act for violating this grant of authority. Something like if your employer says, you can use the computer to do work, but not personal stuff. If you're certainly allowed to bring in a newspaper, like an actual physical newspaper, to your employee or your employer and read the sports page, right? That's okay. But if you're at work and your employer hasn't said that you can use their computer to go online and check ESPN.com or something like that, and you do that, you've violated, in theory, the grant of consent from your employer, and that by doing so, and that you've maybe committed a federal crime, that could be considered computer hacking. So I bring up these cases to show that the Computer Fraud and Abuse Act, as is very, very broad. Not all courts have agreed with stretching this. DOJ doesn't prosecute cases like this. But when read literally, cases that are just a smidge outside of whatever consent was authorized by the owner of the information system could be illegal. Okay. One last case on kind of the Computer Fraud and Abuse Act. We usually think about computer hacking as being very sophisticated. That's certainly true, but not all the time. In this case, US v. Carrera was involved an agent for the St. Louis Cardinals who had a database of all this scouting information. So this is intellectual property information that baseball, among other things, is a business, right? So this is very valuable scouting information that was top secret for the St. Louis Cardinals. He switched, he went over to the Houston Astros and brought his database with him. And now the Houston Astros owned all that intellectual property. One of the employees of the Cardinals said, you know what, I bet he didn't change his password. And they went online and they were able to access the database. He hadn't changed his password, and they just used his old password. That case was prosecuted. The employee of the Cardinals ended up just for guessing the password correctly. That's computer hacking, pled guilty and was sentenced to 46 months in custody. And that case, again, shows that how quickly you can run afoul of the Computer Fraud and Abuse Act, and that there can be serious consequences of it. Vulnerability disclosure programs, I think the whole point here is, like someone said in one of the earlier panels, are, among other things, they are a means for hackers to protect themselves. They set the rules of engagement, and they show where the guidelines are, what the authorization is, and where it's not. They're also a means for companies to protect themselves. For a company to say, okay, we are giving just a very small limited consent to hack this system and this system only, and these are the ways in which we want it done, but nothing beyond that. So that's the role that vulnerability disclosure programs play within the law. Okay. So this has been touched on a fair amount earlier, that there's been an emerging trend toward encouraging vulnerability disclosure programs, in particular on the federal level. You've heard this throughout today. Several years ago, if a security researcher disclosed a bug to a company, to the government, they were greeted with cease and desist orders, threats of lawsuits, et cetera, not warmly received. That's definitely changing, and the fact that we're here at this conference is clear evidence of that, and changing in a pretty dramatic way. I will just add a couple points to other places where this has been changing. We've heard about the NTIA put out draft guidance encouraging the use of vulnerability disclosure programs, including a sample program. The FTC, the Federal Trade Commission, which regulates cybersecurity, said it doubled down on that and said, we think that's a good thing, and that when we're evaluating a company's cybersecurity, we might consider whether or not they have a vulnerability disclosure program in the right case. And of course, cybersecurity frameworks, ISO and NIST are also starting to implement this in a much more aggressive way. Recent legislation is a Warner-Gardner bill that has come out recently that says, just proposed legislation, and it's focused on IoT makers who sell to the government contractors. It is a clear attempt by the sponsors of the bill to improve the cybersecurity of IoT devices by doing a wide number of things. There's been a sense, especially after the DDoS attack from last October, the used IoT devices, that this is an area where cybersecurity needs to be improved. Relevant here, one part of the bill, a major part of it, is to require government contractors who make these devices to have vulnerability disclosure programs. And as part of that, the bill also provides a very broad good faith exception under the Computer Fraud and Abuse Act, separate and apart from whatever the company says about its vulnerability disclosure program. So a really aggressive legislation that, if it's passed, would start to mandate a lot of the things we're talking about today. Okay. So next I want to talk about some of the benefits and risks of vulnerability disclosure programs. We've heard all day long about the benefits. I'm preaching to the choir here a little bit, but I'll add on to that. The benefits really are potentially pretty extraordinary. The idea is to improve cybersecurity in a cost-effective way, but also to do it in a way that really would be impossible to replicate in-house. It's going to be, when you're in the process of developing a product, it's just very difficult to be focused on security at all. And that's doubly true when you start considering the market pressures to get a product out as fast as possible, to beat your competitors, et cetera. That security is difficult to implement. And it's just, I think, human nature that when you're developing something, you're not going to be able to do the out-of-the-box thinking that an external team of hackers would be able to do. So I won't dwell on this, but the benefits are very real and very clear. But there's reasons for caution. And I want to touch on those a little bit and explain what companies should be thinking about when they're considering whether or not to set up a vulnerability disclosure program, what their concerns are, and kind of explain that a little bit. And a lot of what we're talking about here are vulnerabilities that are prematurely disclosed and some of the negative effects that can happen there.
scaring consumers. You can inform competitors of your weaknesses. It could cause for government oversight, and it can result in litigation when vulnerabilities are disclosed prematurely, not in a way that would be in the best interest of the company. And of course, it can facilitate hacks. If a vulnerability is disclosed and it's not fixed, then the public knows about it and it can facilitate hacks and have the exact opposite effect. The one thing we've talked about too, which I mentioned in the last bullet here, are that companies, that this really is a matter of trust and building relationships. I think the last panel really illustrated that wonderfully about the back and forth that they had in earning trust from the companies and also the companies earning trust from them, and really a two-way street there. That doesn't happen overnight, and it doesn't happen just because a company puts up security at company.com, right? There has to be a lot more involved in this. And from the company's point of view, obviously, hackers have a bunch of mixed motives. And it is difficult for a company to know initially who has sent in this vulnerability. Is it a competitor who's lying? Is it somebody who has spent the last 3 years exfiltrating tons of our data and they've decided to cover, they want to get kind of a waiver and get some good faith because they're worried they're going to get caught, so they submitted a vulnerability to the company? Who is this person? And to illustrate that, I'll mention briefly a case I was involved in prosecuting back when I was worked for DOJ. It was an individual who did some activity that was clearly black hat hacking. He had taken over a ton of accounts and was stealing hundreds of thousands of dollars. And we had chats that were in which he said stuff to his co-conspirator, things like, thank goodness we're robbing all these people or else we'd have to get real jobs. So very helpful as a prosecutor. So the prosecution made a lot of sense based on that conduct. A pretty easy call to do that. He also engaged in what I think was clearly white hat hacking and a little gray hat. With a separate other company, he was doing things like had gotten into the CEO's emails and was reading through them, mostly for his own fun. He wasn't publicizing them, but also didn't report that at all. But then had found with the other company, the second company, other vulnerabilities that he said and to some extent had tried to report to the company. And so here's somebody that, what do you do with somebody like that if you're a company? This is somebody who's clearly stealing from another company, and yet they might be providing, company B with valuable vulnerabilities in a way that's very honest and helpful with that second company. I don't think that story is too uncommon. And certainly it is a story that companies fear when they set these up, that the person that they're dealing with on the other end might be engaged in giving great vulnerabilities, but also nefarious conduct. Okay. So what is, just a couple notes on what does this look like in practice when a vulnerability disclosure goes wrong. The GPAC that you're going to hear a little bit more about tonight, I won't dwell on it, first reported in Wired. They came forward, clearly good faith security researchers, doing good journalism, and they published this. And the results to Jeep have been testimony before Congress, investigations, and litigation, all because of the vulnerability that was reported. No actual hack that caused an accident, nothing close to that, but just the reporting of a vulnerability has had severe negative consequences for the company because of the way in which it was released. And done so, like I said, through journalists, not nefarious hackers. The last one on here is another example of premature disclosure that a company, I'm sure, did not appreciate. And this one, security researchers found a vulnerability in a pacemaker. They did not call the manufacturer of the pacemaker. Instead, they went to Wall Street. They shorted the stock of the pacemaker, the company that made it. Then they disclosed the vulnerability. The company's stock tanked, and they made money on that. Another example of something that is dubious legally and perhaps morally as well, but prematurely disclosing a vulnerability in a way that has pretty negative consequences. Everybody knows about Google's Project Zero here. I'll just mention it briefly because I know there are a lot of people here from companies, and they're kind of wondering, yeah, do I have to get involved in this? And as I'll get into, there's a lot of reasons to do so and maybe some not to do so. But this is, Google's Project Zero and other things like this indicate that a company has to have thought out what it's going to do when outside sources provide vulnerabilities to the company. Google's out there with a dedicated team of smart researchers who are picking and choosing their targets based on whatever they decide is appropriate at the time, and it could be your company. And so with somebody like that who has credibility and has more or less stated, if I recall, that they're going to go public with the vulnerability within 90 days, whether you fix it or not. A company has to consider themselves to be potentially a target of Google's Project Zero and to figure out how they're going to react to that, especially depending on the space they're in. Setting up a vulnerability disclosure program. With that background, I want to go through a couple of the considerations and amplify some of the themes that you've heard already today. And we'll go through with 5 of them here. The first is whether or not to adopt a program. I think one of the points that was made in the last panel, which I absolutely agree with, was if you're not ready to adopt it, you should not adopt a vulnerability disclosure program. And for reasons we'll get into here. But you're not going to be able to respond and handle and process the reports and vulnerabilities that come in, and that's going to put you in a worse situation. Companies also have to talk about and intelligently decide how they're going to scope a program, how to staff the program, whether or not they have the resources, how and they're going to document their triage methods and how they resolve reports, and to understand some of the notification obligations they may have to third parties. So I'll just walk through each of those points in a little bit more detail. So to adopt a program or not, they're not right. These programs are not right for all companies. We'll come to resources in a minute, which I think is one major reason not to adopt one. But also, it depends on your business and where you're at. If you're a new company or you're putting out a new product that still is in development or is early or you've just gotten to market, a vulnerability disclosure program there might feel a lot different. It might feel a way to, like I mentioned earlier, scare off customers or inform your competitors of what you're doing or your weaknesses. The NTIA sample policy that I mentioned earlier allows hackers to engage in reverse engineering and circumventing protective measures, and it provides a really broad grant of immunity to anyone who submits a vulnerability report. That is, I would be hard-pressed to imagine recommending to a client that they ever adopt something that's that broad and really leaves the company without any recourse for situations in which a hacker has submitted a vulnerability program, on the one hand, a vulnerability report, but maybe on the other hand has engaged in nefarious hacking against your company or works for a competitor and is trying to steal your trade secrets, et cetera. That is a really permissive vulnerability disclosure program that I think would be challenging for many companies to adopt. Scoping the program. Heard about this again throughout the day. This is a very critical issue. So scoping can be, like we heard about with the DoD program, maybe just a single public-facing website, or it could be much more detailed. If your vulnerability disclosure program is simply security@company.com, there's a couple things with that. There's no scoping on that, but also there's no granting of consent to hack, and I think that's something that's worth noting, that if that's what a company decides to adopt as a vulnerability disclosure program, they've really not waived any rights, and they haven't provided any protection for hackers. And so much more, a place to be much more on guard as a hacker dealing with a company where that's the full scope of their vulnerability disclosure program. But then as companies really
spell out and have fully fleshed out and well thought out programs, that's where you're going to get into the scoping. Okay, we're now ready for this. This is our time frame. This is who can participate. Working, as we've heard earlier today, in baby steps is a way to for the right company to start this process in a way that's going to make more sense. Resources. So I advised a client, I don't know, within the last year or so, not to set up a vulnerability disclosure program. They were a tech-savvy company. There's no cultural issues or anything like that. They were, in fact, very excited about it. But in discussions with them, we realized that they had no process in place to triage reports, to document them, to respond to hackers, and to resolve out vulnerabilities. They just weren't ready to do it. And the concerns for that, there's many. One is if you are non-responsive to a group of hackers who are hitting your system and finding vulnerabilities, then you're going to create a lot of angry hackers, and that's probably not a good idea. The other part of it is that it's going to, and this spills into the next point a little bit, you're going to have terrible documentation of your company's cybersecurity posture. And that may be okay until a cyber incident happens. And so the concern is, and what I talk with companies about, is if you have set up a vulnerability disclosure program that's maybe just as simple as Security Act company name, or something more fleshed out, but you're not resolving those vulnerabilities and fixing them, you are putting yourself in a bad position for litigation and regulatory oversight, especially if a cyber incident happens. As we heard at the top of the day, a vulnerability disclosure program can find the vulnerabilities for you, but it can't fix them. Companies have to do that themselves, and sometimes that's very easy. It's okay. Oh, here's the problem. Fixed. Done. We get something. We pay out the hackers within 24 hours. Everything's fine. That's not always the way it works. And it's really difficult to tell when a vulnerability comes in, do I trust this person? Is what they're saying accurate? How quickly can I verify it? And even if there's that trust and verification, how quickly can I fix it? Do you have the resources to do that? So again, the concern is that post-incident, plaintiffs' lawyers, the FTC, or some other regulator is going to come to a company, they're going to just get these materials through discovery, and they're going to say, you had a cyber incident, and you also knew that with respect to your application, you had 400 bugs that were reported to you, and you didn't do anything with them. That would be not very good for the company. Even if those vulnerabilities had nothing to do with the cyber incident that happened, it would just be something that regulators and plaintiffs' lawyers would point to and say, this shows you weren't serious about your cybersecurity. I think I covered most of this. How are you going to resolve your reports? How are you going to document it? It's not always the case that every vulnerability that comes in should be fixed immediately. I mean, there are business realities that might say, okay, that vulnerability, it's verified, it's real, but the fix would just be incredibly expensive for us at the moment, and we've looked at it, we've appropriately triaged it, and we just think that there's a really low risk of this being exploited. That is an appropriate response for a company to do. That makes sense sometimes. It's not that every time you hear about every potential imperfection in cybersecurity, that you must spend the max to fix it. That doesn't make any sense. But how you document that and create an internal paper trail showing that you're serious, that you thought this through, and that you do have a good business case for your decision to not immediately fix a vulnerability. That's going to be really important when you're faced with litigation or with regulators. Another piece of this, and I'm just going to flag this is a much broader topic. What do you do when you get a vulnerability about notifications? And this can come up in a myriad of different ways. A vulnerability that's related to your own systems, and say you have an application that you're selling to numerous other businesses that they're using, you realize that there's a problem in there. What are your responsibilities for patching that? Assuming you are able to do that quickly, what do you have to do to notify them? If you're involved in critical infrastructure or making pacemakers, things like that, what are your notification obligations there? Do you have to tell a regulator or the federal government about a vulnerability if it becomes of a certain level or certain seriousness?
What if you find a vulnerability in your competitor's product? Do you want to be in a position where you go and tell them, or do you want to keep it quiet? Those are all things that should be thought out beforehand in setting up a vulnerability disclosure program and present a wide range of other issues. Okay. You've been very kind with your time. Thank you all very much. And I know I'm standing between now and lunch, so I'll try and get off the stage pretty quick. The overall conclusions here, I think, are the clear beneficial impact for vulnerability disclosure programs to improve cybersecurity is very real. And there's a lot of excitement and potential about this. But in setting one up, I think that each company, when they're figuring out how to do that, has to make sure they're doing it in the appropriate way, that they can communicate appropriately with hackers, and that they've thought through a lot of these issues that I've flagged. All right. Thank you all very much. I appreciate it.